Hey everybody, and welcome to our Easter edition of Litigation Lessons on the Renters' Rights Act 2025 with myself, Graham Mead, and Ellie Claffey.
Good morning.
So firstly, thank you for coming. It's lovely to see you all, and thank you for making the effort just before the Easter break. Just a bit of housekeeping, if I may, to begin with. As with all litigation lessons, we try and guillotine our talks to around an hour. It'll be a brief overview of the Renters' Rights Act. Because the Renters' Rights Act is still, in its infancy, as it were, and we're still waiting for a lot of further information to be rolled out by the government and for developments in case law and updates, we have decided not to take questions today as part of this seminar because we've got a lot to get through. But if you can email us with them, we will happily come back to you once we know a little bit more. And we think that's an easier and better way to deal with it. By way of disclaimer, as I say, today is an overview. We can only deal with so much in an hour. So the aim is to give you a flavour and the sort of highlights, as it were, and things to watch out for. So if you do have any detailed issues, again, please do get in touch with us. After the talk, we will email you the slides. Next week, we're working on preparing a fact sheet, which will set out common questions which we have had so far, and we'll also look to update that and add in any that we receive today. After the fact sheet, we'll also be following up with an opinion piece just to kind of give more of a detailed sort of thought process, thought leadership piece around the Act and its impact. And finally, I know I always say this, but Pretties is a learning organisation. We take your feedback very seriously. And so if you could take the time to complete your feedback forms, and on that form, there is a section that asks you to put forward any future talk topics that you would like us to address. Can we ask you to fill those in? And finally, our contact details will be available at the end of the talk. So today we're going to, as I say, deal with the highlights, some of the background and the rationale behind the Act, touch on the key changes, touch on the timeline and the key dates, and also conclude really with what we consider the consequences of the Act could be. So to begin at the beginning, the background and rationale behind the Act. I remember way back in the days before COVID, the last talk I gave before lockdown was actually to the ICS in regard to possession proceedings and the future of possession proceedings, and they wanted me to major really on the future and what was going through Parliament, the legislative at that time. And broadly, having looked at the various consultations around then, and I'm obviously going back 5 years or so, the general feeling was that from when the current sort of assured order tenancy system was brought in the 80s, people's renting habits had changed. We weren't looking, as we had been in the 80s, at shorter term lets of 6 to 12 months. We actually now had a scenario where 3 to 4 years, I think it was the average rental sort of, the tenant would take a property, stay there for 3 to 4 years and then leave. And they were getting and seeing, as it were, the surveys were showing much longer lets, sometimes 10 years plus. And the feeling was that this wasn't actually covered by the current scheme. The current scheme was aimed at, as I say, short-term lets, mobility, came out of the 80s when there was a lot of transformation. And so the system was possibly out of kilter with how it was being used. The reasons for this seem to be sort of a mixture. Some were sort of just saying the millennials have a different outlook and want to rent and not commit. Others were basically saying it was because house prices were so high that basically young people couldn't afford to get on the property ladder, and we obviously made that to be true. But there did just seem to be, ignoring all of that, looking at the demographic, a general sense of people renting for longer. So the Tories brought in, and were looking to bring through, the Tory government was bringing through the Renters Reform Bill. And the aim of that really was to do away with what we call no-fault evictions, or Section 21 notice evictions, where the landlord can give the tenant 2 months' notice, and provided the notice is served properly, they effectively are entitled to possession, and a district judge, when coming to assess a possession claim, if a Section 21 notice has been used, she has no discretion to do anything about that. It's mandatory. The feeling was that was unfair. If you've been in a property 10 years, if you've got kids at the local school, if your job is just round the corner, it's unfair to expect you to pack up your life in a box and start again, and only on 2 months' notice. The Labour government then came in, and they, in the manifesto, said transform the experience of private renting. That was one of their promises. And they basically took the Renters Reform Bill and they beefed it up and added a load of extra rights. And that act, the Renters' Rights Act, came into effect on the 27th of October with the rationale, and I've given you the background, to end the insecurity of no-fault evictions, i.e. Section 21, improve the standard of rented properties, prevent exploitation of renters, and increase the accountability of landlords. I'll now hand you over to Ellie for more details.
Thanks, Graham. So now moving on really to the changes that the Act has introduced. Now, the first change to discuss is ASTs. Now, assured short-hold tenancies are being abolished. Under the Act, ASTs are set to become assured periodic tenancies on the 1st of May, and that is going to apply retrospectively. So if you have a current assured short-hold tenancy agreement, and that tenancy is automatically going to become an assured periodic tenancy on the 1st of May. So what is a periodic tenancy? Well, a periodic tenancy is simply a rolling arrangement. So it follows the rent cycle, usually month to month, and it just continues until somebody serves notice. Now, the key difference between periodic tenancies and the ASTs, which we are all used to, is that the landlord cannot let for a fixed term, i.e. 6 or 12 months. Now, for tenants, this is going to create much more flexibility because they'll be able to leave with 2 months' notice at any point, even from day one. However, for landlords, generally, I think we're going to see it creates more uncertainty and less stability with no guaranteed long-term income. Now, with that change to periodic tenancies, the fixed term renewals, which we are used to, disappear. Previously, the end of the fixed term point was the natural point to sit back and review the tenancy and the rent. And without this, we will see a move to a more structured rent review process, replacing those renewals. Now, Graham's going to touch on this in more detail later, but letting agents really are likely to feel the impact on this, with the potential loss of revenue coming from that renewal work. Now, with the change in the tenancy type, we are also going to see a shift in how that tenancy is documented. So from the 1st of May, landlords must give their tenants what is being called a written statement of terms, and they must do this before the tenancy starts. This written statement is intended to make expectations clear from day one. There is no prescribed form for this written statement, but it will need to include the key information like landlord details and tenant obligations. Now, I've included a link on this slide, which takes you to the government-produced guide for landlords. This sets out everything which the written statement needs to include. Now, the recommended way of dealing with this requirement is to incorporate the written statement as part of the assured tenancy agreement. Now, you may find that the precedent tenancy agreement, which you already use, deals with a lot of the required information, but you must check this and amend your precedent as necessary before relying on it. Now, you don't have to adopt this approach. If preferred, you could also serve the written statement as a standalone document. Now, for new tenancies, which is set to commence on or after the 1st of May 2026, the written statement needs to be served before the tenancy starts. Now, if you already have a tenancy, but it is limited to an oral arrangement with nothing in writing, then you must, by the 31st of May 2026, serve each of those tenants with a written statement setting out the terms of their tenancy. Now, this is essentially to put the status quo into writing. Now, providing that you serve this written statement, then you do not also need to later serve the information sheet, which I will be coming on to later. Now, one of the major controversial changes which has grabbed the attention of this Act is the abolishment of Section 21 notices. Now, Section 21 evictions are commonly referred to as no-fault evictions on the basis that the landlord does not need to justify the eviction or provide any grounds to evict. Now, it has always been a mandatory process, meaning that providing all the relevant compliant documents have been served correctly, then the landlord would be entitled to possession on not less than 2 months' notice. Now, so frequent in their use, the court had what we call an accelerated possession procedure route to deal with these applications on paper and without a hearing. Now, the process was as simple as it could be, and as a result, it was widely utilised by landlords, even where they had valid grounds to evict. However, this well-trodden Section 21 no-fault procedure is being abolished, and landlords will no longer be able to end a tenancy without giving a valid reason. Landlords will instead be forced to utilise the newly revised Section 8 procedure, and there will be a court hearing for all possession applications. Now, those of you who have been through it will be aware that the process from issuing proceedings to obtaining possession in the courts via the standard Section 8 route was far from quick, and would typically take around 6 to 7 months. Now, without the accelerated possession procedure option, it is thought that there will be a further influx of matters requiring court hearing, adding to the administrative burden. So we can expect this process to take even longer as the court backlog increases. So I am sorry to say that this change is likely to slow the process down, and it is something which will have a significant impact, particularly if evicting on the grounds of rent arrears, as rent arrears are going to continue to accrue while the matter is processed through the courts. Now, there have always been many grounds to evict under Section 8, some mandatory and some discretionary, but they are expanding even further to deal with the changes made and the abolishment of Section 21. So these expanded grounds of possession, as I've said, they continue to be split into mandatory and discretionary grounds. There are too many grounds to go through in this webinar. We only have an hour, and I fear it could be a bit of a repetitive watch. So I would therefore suggest that you look at the following link, which lists all of the new and updated Section 8 grounds. Now, for the purpose of today and this webinar, I'm going to just touch on the ones that I believe are going to be felt most in practice. Now, the first major change I want to address is around rent arrears. Previously, landlords could rely on 2 months arrears as a mandatory ground for possession. That threshold is now 3 months arrears. This means that the tenant must owe at least 3 months rent before the ground to serve the Section 8 notice is available. In addition, the notice period has now doubled from 2 weeks to 4 weeks. And so a further month's rent is going to have accrued before that notice even expires, and before the landlord has the grounds to seek possession in courts. So the bar for mandatory eviction has got higher and the process has got slower. So a further and important point to note around rent arrears is universal credit. Now, if a tenant is eligible for universal credit, then we will need to take that into account when calculating the amount of arrears. It is known that the universal credit system can be slow and can result in payments being delayed, and that can have a knock-on effect on tenants who rely on it to pay their rent on time. So the rationale of this safeguard is to prevent the tenant from being punished by the Department of Work and Pensions' failure to pay universal credit on time. Now, we do not have the time to go into detail of this safeguard in full today, but the takeaway really should be that if your tenant asserts that their arrears are due to being a universal credit issue, such as delayed payment, then you should be careful to use this ground or initiate possession proceedings without first taking advice. Now, the next important change relates to situations where the landlord needs to sell the property or wants to move back in. These grounds still exist, but with new safeguards. So they cannot be used in the first 12 months of a tenancy. Now, this means that if you let your property in April 2026, You cannot serve notice to terminate that tenancy on the grounds that you or your family needs to move back into the property yourself, or you need to sell that property on a date which is within that first 12-month period. Now, further, if the landlord uses the sell ground, they cannot re-let the property for 12 months afterwards. So it is important to fully understand this and make sure that you know what you can and cannot do before serving a notice on these grounds. Now, there has also been a new ground introduced, ground 4A. This specifically deals with landlords of student houses of multiple occupation, and providing that the landlord gives the tenants advance notice that they may seek to rely on ground 4A in the future, then they will be entitled to terminate in accordance with the academic year, providing that they are reletting to other students. So if you are or you have a landlord of student HMOs on your books, then understanding this ground 4A is going to be critical and giving notice essential. So I would just encourage you to take some advice. Now, more broadly, across all of the grounds, most notice periods have doubled. So, for example, grounds that previously required 2 months' notice will now require 4 months, giving tenants significantly more time to plan and respond. Now, this, coupled with the court backlog, the process from start to finish is probably going to take much longer than it has historically. Over to you, Graham.
Thank you. So, as if the changes to Section 8 weren't enough, we have the extra change in regard to rent reviews. Now, currently, most assured short-term tenancies have a specific clause in them that deals with a rent review process. These will all now be void. The Act brings in one statutory rent increase procedure, which is dealt with under Section 13 of the Act. And in summary, it works like this. There is going to be, we haven't seen it in its final form yet, but there is going to be a new notice, the Section 13 notice. In that notice, the landlord will specify what they consider to be the new rent. Again, as we're saying, we have to be sort of, I think, more cautious than we were in terms of putting out rent to ensure now that it's in line with market rent. And so again, you may need to consult with your letting agent or, look a little bit more closely in regard to how you're going to increase, what you're going to increase by. The Section 13 notice, as I say, specifies the new rent, and it has to be served giving 2 months' notice. So far, so good. However, if when the tenant receives the notice, they are unhappy with the proposed increase, the Act brings in the ability for them to challenge the amount by taking the matter to the first tier tribunal. The first tier tribunal exists at the moment. It's very much the court that deals with a lot of land issues, sort of sweeps them up. It's meant to be user friendly and everyman court. But there are proposed changes, I think, to the first tier tribunal to deal with all of the Renters' Rights Act changes. But at the moment, the first tier tribunal, like every other court in England and Wales, is pretty busy and has a backlog. So I guess where I'm going with that is the tenant, if they want to challenge, can take it to the first tier tribunal. That may lead to a backlog. We're waiting to see how that develops. Once it's before the first tier tribunal will really be looking at seeing whether that increase is just and equitable. We don't actually have a lot of guidance around that at the moment either. I'm guessing they'll look at what, as part of the process, you may have to file out reports or updates from your letting agent, from a surveyor or similar. We just don't know where that's going to go. We don't know whether they're going to have tables which will guide everybody going forward. We don't have the rent controls that were in place from back in the 1970s. So it's very much at the moment sort of based on the increase being, as it were, proportionate. The first tier tribunal cannot, as the current regime allows, increase the rent. It can only accept it as that amount set by the landlord, or it can reduce it. Now, At the moment, the fact that the, as it were, tribunal, the rent tribunal, lands tribunal can increase that rent means that there is almost like a double threat to the tenant. On the one hand, they may want to challenge the rent, but they know that if they do, they may end up actually getting a higher rent than they want. So there's a little bit of jeopardy there. With this system, that is obviously removed. And so I think if you've got a sort of a tenant who is perhaps a little bit more spiky or feels that that rental increase isn't in line, you are going to get a lot more tenants under this system applying to the first tier tribunal. The first tier tribunal is cost neutral. Thank God I hear you say, at least I'm not going to go down for costs on this. But I think the difficulty is, again, we don't quite know what the system will require, whether you will need a lawyer. It's, as I say, it's supposed to be an everyman court, but it is a little bit ambiguous. The other point to mention here is that the rent increases, once they've been decided by the first tier tribunal, cannot be implemented retrospectively. So again, I don't want to pick a nightmare scenario, but you write to the client on, say, the 1st of December with your rent increase, you give them the 2 months, so basically 1st of January, 1st of February. They're not happy with it, so they wait until the end of that notice period or even a short while afterwards. There doesn't seem to be a limitation on, as it were, necessarily when they can appeal. We don't know, apply to the first tribunal, we don't know that yet. It goes to the first tier tribunal, and let's say it takes, I don't know, I don't want to be too doom and gloom, let's say 3 months. I think it'll probably be more like 6, but 3 months. So you're already, as it were, by the time it gets to the first tier tribunal, potentially 6 months, if you're following me, behind where you started out. Then they make their decision, okay, you can have it, or even worse, okay, you can't, I'm going to pick another one, another amount, and then you can only introduce it from the period they make their judgment going forward. So you're always going to have this lag, if you see what I mean, if this happens. I appreciate not everybody has tenants like that. I'm sure, going back to my long-term renting comments, that there'll be some who will just accept it. But I think it is going to put a lot more scrutiny on the figure of the rent increase. And I think there's going to be sort of a need for landlords to kind of look carefully at that increase. It's going to be more focused. Final point on rent reviews. You're entitled to one every 52 weeks, so one a year. But that's not in the first year. The first year is set at what you market the property at and they sign up for. 12 months passes, and then we're, as it were, up for the next one. So I suppose the only other thing, based on what I'm saying, is it's probably better to look, if you're going to increase your rent, doing it nearer the start of the 52 weeks rather than at the end. Anyway, that's rent reviews. Second further new aspect in terms of rental and rent and levels is rental bidding. Now, I don't think we see too much of this in East Anglia. It seems to be more around London and obviously the cities where property is at a premium. But what I understand happens in London is a property is marketed at a rent that the letting agent thinks is appropriate. First potential tenant comes in and says, I'll take it at that rent. Then another sort of individual potential renter who's looked around comes in and says, I'll take it. Letting agent says, well, we're taking, I don't know, £2,000 a month for that. Second chap says, we'll take 2.5. Then the third chap comes in 3, then 4. And we end up with this sort of auction where the price goes up and up and up because good property is at a premium. That is all barred under the Act. Now the landlord will, or the letting agent or agent, will advertise the property at a rent. Once that rent is accepted, as it were, by the first tenant, that is it. No bidding up, no renegotiation. That is where it sits. And if you don't play by those rules, then there are financial penalties that can come into play of up to £7,000. This will only apply in England. Wales gets away with it, as it were, for the time being. But I think, again, just more scrutiny, more concern, and more limitations for landlords, which again makes the importance of getting that market rent or that rent level so important to begin with.
Thanks, Graham. So moving on slightly to something a little bit different, we've got pets. Now, this is one of the changes which really has got a lot of attention, perhaps not surprisingly. I know pets are becoming more and more like family, but as you may have heard, there is a new right now for tenants to request permission to keep the pet. Now, under the Act, tenants now have the formal route to ask for permission to have a pet, and landlords must treat that request fairly. There will be no more blanket bans on pets. So the request for a pet must be in writing, and it needs to include a description of the pet so that the landlord knows exactly what is being proposed. Now, once that request is made, the landlord has 28 days to respond, and a failure to reply within that time frame will be treated as unreasonable refusal. Permission cannot be unreasonably refused. So what is unreasonable refusal? Well, that really isn't clear cut at the moment. And I think we're going to see a lot of case law develop in this area as tenants are going to seek declarations in the courts to justify their weird and wonderful pets. So as this may provide us with more guidance in the future, for now we're looking at what is objectively reasonable. Now, for example, it's objectively reasonable to refuse a pet if that animal being proposed is dangerous or poisonous. But generally, the circumstances where a landlord can reasonably refuse are likely to be rare. Now, saying that, it should be noted that a landlord can refuse a pet if it is prohibited by their superior lease. So, for example, if the landlord has a long lease of a flat and that long lease prohibits pets, then the landlord can reasonably refuse a pet when reletting that flat so as to not put them in breach of their superior lease. Now, previously, there was some talk that landlords could compel tenants to take out pet insurance, but that has not made it into the Act. And so there is no grounds a landlord can sort of conditionally accept a pet if that tenant, for example, obtains insurance. Now, the overall aim here is to give tenants a fair opportunity to keep pets while still allowing landlords to refuse where there is a genuine evidence-based reason. We will see how it develops in practice, and I, for one, will be keeping an eye on all the weird and wonderful pets that tenants try to get through the door. Now, on a sort of similar note here, we are moving on from a blanket ban on pets to now considering blanket bans on the certain types of tenants. So discrimination in the private rented sector is something which has been considered an issue for some time, with tenants being turned down rental opportunities before even really being given a chance. The focus of these reforms is on two common areas of unfair treatment: tenants with children and tenants who receive benefits. Now, under the new rules, both direct and indirect discrimination in these areas will be tackled. Now, despite everything I am about to say, it should be noted that landlords do still retain important rights. They can decide who the property is ultimately let to, and they can carry out referencing checks to make sure that the tenancy is affordable and sustainable. Those checks are going to remain entirely legitimate. However, what landlords cannot do is refuse a tenancy because someone has children or because they are in receipt of benefits. Those blanket policies like no DSS or no children are now going to be treated as discriminatory and unlawful. Now, it is an interesting area, and the concern is that landlords and letting agents will face accusations of discrimination for favouring a prospective tenant with a 9-to-5 job more highly than a prospective tenant on benefits. Now, that's going to be particularly relevant in situations of rental bidding, where a property is particularly competitive to obtain. Now, the key here is the reasoning behind that decision. A refusal based on a genuine affordability concern, evidenced through referencing, is going to be allowed. But a refusal based purely on the protected characteristic or personal preference is not. So breaches of these rules are going to carry financial penalties of up to £7,000. And that's going to signal a much firmer approach to fairness and equal access in the rental market. Now, it's important for landlords and their letting agents to really understand what they can and cannot do here and avoid falling foul of the rules or being accused of such. Now, moving on now to something entirely different. The Act is introducing a new private rented sector database. Now, this is a major structural change in how the sector is regulated. For the first time, landlords will be required to register themselves and each property that they let. The aim is to create a single, reliable source of information about who is operating in the rented sector and what properties are being rented out. Now, tenants will have access to the database before and during their tenancy, and it is intended to increase transparency. So they will be able to check that a landlord is properly registered and that that property meets the required standards before they commit to the tenancy. So, for example, it is thought that EPCs and gas safety certificates will need to be uploaded to this database. And although not yet confirmed, it is also considered likely that the regulations will come in to mean that a landlord cannot commence possession proceedings against a tenant if there is no record of EPC or gas safety certificate on the database. Now, that would, of course, mimic the requirements under the Section 21 procedure, which we are all used to seeing today. Now, local councils are also going to benefit from this database because the database will give them accurate information for enforcement. That means they can target their resources more effectively and identify non-compliant landlords more quickly. Further, the database is also going to be shared and fully visible to HMRC, who will also be able to compare against their own records. Now, I know what you're thinking, where exactly here is the benefit to landlords? Well, for the compliant landlords, the benefit is that the database will help them to understand their legal obligations and to give them a straightforward way of demonstrating their compliance. It will provide a platform for communicating regulatory updates, so landlords receive up-to-date information directly rather than through third-party sources. Overall, the database is about raising standards, improving transparency, and creating a more consistent and accountable private rented sector. Now, we haven't got the dates yet for the implementation of this database, but it is expected to be up and running at some point between 2026 and 2028. Thanks, Graham.
Thank you, Ellie. So, we've heard about the database and you're needing to register with that if you're a landlord. There's also now the private rented sector landlord ombudsman. Now, this is a new mandatory service, and again, all landlords will need to register for this. It's a free service for tenants to use. I don't think that means that there's going to be any charges for landlords, but it's marketed as free for tenants to use to complain about a landlord's actions or behaviours. And again, that's pretty vague in terms of what we know so far. The ombudsman will have the power to compel an apology from the landlord, ask the landlord to provide information, ask the landlord to take remedial action, or ask the landlord ask the landlord to pay compensation to the tenant. So again, on top of everything that we've been through, more regulation, more risk. The only other point I would make just before I move on is the ombudsman can compel information from third parties. And based on the courses that we've been on, it looks as if the tenant, the ombudsman, can look for information from, say, the landlord's accountant, a letting agent, or linked third parties. So again, it's wider than it has been, and again, I flag that. Consequences for failing to register or for marketing a property which the landlord is not registered for. Well, a civil penalty of up to £40,000. It's worth also mentioning at this point, I mean, we've touched on the local authority having access to the database and talked about local authority having sort of extended powers. Under the Act, it looks really as if the local authority is becoming the enforcer of all of these aspects. You know, the first tier tribunal says do this, likely to be enforced by local government. Ombudsman does that, likely to be enforced by local government. So local government is going to play a bigger part on that. And I suppose I'll come on to this shortly, but they're going to sort of potentially be incentivised to do it because, as I understand it, those fines, or at least a proportion of them, not all of them, but a proportion, can be kept by them. So again, I've had a lot of people say, well, why would local authorities care? They're under-resourced, as it were. But again, it's a way potentially to gain more income. Failure to comply with the Ombudsman's, I should go back. On top of the civil penalty of up to 40,000, the landlord can also you'll face criminal prosecution with an unlimited fine. And there's also the risk of rent repayment orders being made, which I'll come on and touch on later on. Failure to comply with an Ombudsman's decision may result in their expulsion from the scheme. Based on what we know, it's mandatory for you to register. I think the implication is if you then get expelled from the scheme, you can't then let, albeit it has been made clear that there is a route back to rejoining the scheme if you have been remiss. So again, although that sounds like you're expelled from the scheme, so what? I think it will have teeth. It obviously then stops you being able to rent. The last point which I make is the Ombudsman has been made very clear their decisions will be fair and impartial. So I guess that means we don't have to worry. Decent home standard. Now this is a sort of a scheme, a policy that's again been brought in by the government. The aim is, as we've said on the slide, to incentivise landlords to proactively manage and maintain the safety and decency of their homes. Now, I think this is all part of the Renters' Rights Act, this push by the Labour government to give more equity to tenants and, in theory, more rights and fairness. As I've said, it gives local authorities enforcement powers, such as issuing an improvement notice or issuing civil penalties. Now, don't worry too much, it doesn't come in until 2035, so there will be breathing space. But just to come on, and you can find out more about Decent Home Standard, there's a whole section on it on .gov.uk, but just in summary, it says that a home, and I suppose note the language, not a house, not a rental, it's a home, must be free of dangerous hazards. And by that it means, basically, I'm sure you're all aware of the HHRS, the health and safety scheme that's been implemented in terms of properties, category 1 hazards under that scheme. So it must be free of dangerous hazards. It must be in a reasonable state of repair. It must provide minimum core facilities and services, flushing toilets, running water. It must provide thermal comfort, so it's got to be warm. And it should, so not must, but it should, bit of a break there, should be free of damp and mould. So again, 2035, but the reason we've included this is it's mentioned in the Renters' Rights Act, and it shows the way that things are going, more rights, more being given to tenants, more protections.
Yeah, so on a similar note to that is Arab's law. And again, I'm only going to touch on this lightly because whilst it is a law which is set to be introduced, it is not something that we're expected to see anytime soon. But the history of this one is one which you may already be aware of. So Arab's law was brought in on the back of the tragic death of a child who died of respiratory issues caused by prolonged exposure to mould in a social housing apartment. So Arab's law was introduced because of the attention that this case brought to the poor housing conditions across the country. First introduced to social housing, we are now seeing that extended into the private renter sector, including properties which require a licence. Now that means that private landlords are going to be held to the same expectations around timely action and safe living conditions. So Arab's law, well, it places a much stronger responsibility on landlords to deal with health-related hazards in rented homes. The core principle being that the tenant reports a potential health hazards such as damp, mould or other risks. The landlord will have a clear duty to investigate that and fix the issue within a defined timescale. The key part of the reform is that these requirements will be implied directly into the tenancy agreement. So in practice, that means that the law sets out the timescales and the obligations automatically, even if they are not written into the tenancy contract. Now, if a landlord fails to comply, it becomes a breach of contract, giving the tenants a clear route to bring a claim. But the detailed rules, such as the exact timescales and how the process will work, are still subject to ongoing consultation, and so the particulars will be clarified in due course. But the direction of travel is clear. Coupled with decent home standards, we're looking at faster responses, stronger accountability, and a legal expectation that health hazards are dealt with promptly and properly.
Thank you. So I've already touched on this a little bit, but this is sort of now coming on to more of the enforcement provisions. So as I've said, local authority powers are effectively being extended under the Act. We know some of them broadly as we've run through, and we know that there are more that are coming in terms of and around the decent home standard and so forth. But we also know the Ombudsman's coming in, the database is coming in, but local authority enforcement, so far, we know this. They can impose fines of up to £7,000 for minor non-compliances. They can impose fines of up to £40,000 for repeat breaches, offences, or serious offences. Or, as I've touched on, they can go for criminal prosecution, which again would be obviously subject to a court fine, which in this instance would be unlimited. And I've also explained that it's a way we think local authorities are going to be able to increase their income because they will get to pocket the fines themselves. So there is an incentive for them, along with the regulatory scheme, to pay more attention. Now, I've said here lawyer up. It doesn't necessarily have to be lawyer up. It could be surveyor up or letting agent up or whatever. But I think it is going to mean that there is much more scrutiny by landlords, as I've said before, on how we deal. The Section 8 grounds are more complex. They introduce words like reasonableness, where we never really had to worry about that before. We are almost potentially, as a landlord, having to perhaps give more justification than we did. Every Section 8 matter now is listed for a court hearing. So that's if obviously the tenant doesn't leave. But what I mean is there is much more sort of scrutiny, there's much more of an evidential burden possibly around this. If you're relying on your letting agent or your lawyer to draft the notice, they're probably going to want to find out much more about the background to this. It's at the moment, a lawyer can draft a notice based on strict instructions. Please draft a Section 8 notice based on ground whatever because of this. We would draft it. Now, having done that, I think we will be warning the landlord to be, doubly sure whether they meet all the criteria. We'd be warning them about a fine. We'd be warning them about, potential criminal prosecution. So the process goes from simply, I'm not saying this was ever a light procedure, but I think getting your ducks in a row, making sure you've ticked the boxes, and the consequences of not doing so are going to be greater. I also just mention here under the Act, there is a definition of what is a relevant person. Now, a relevant person is really someone that's associated, as it were, with the landlord. So it could be their letting agent, their agent. It's whoever is effectively carrying out work as the landlord or in the landlord's position. Now, all I would say here, both ways, to both those individuals who are doing the agency work and to the landlords, is just check your terms and conditions to make sure what is your responsibility and what is your letting agent's responsibility or your agent's responsibility, just to avoid situations where, if they're serving the notice, they have to make sure it's right. Relevant people, as it were, persons, and attract fines as well under the Act in the same way as a landlord. And so it's important to ensure that whoever is doing the work, serving the notice or taking these steps, maintaining the property, knows what their responsibilities are. And off the back of that, if you're the landlord or if you're the agent, you need to know, are you liable for it? Or is that something you need to, or you are pushing down to the landlord, or, who is responsible just in terms of this liability? And then just coming on, I said I would touch on this, that rent repayment orders are in place at the moment under other legislation. They're being extended under the Renters' Rights Act. So what is a rent repayment order? It's a tenant-led mechanism. So again, the tenant's right. in which if a landlord has committed an offence, they can be ordered to repay an amount of rent. Now, this again is being dealt with by the first tier tribunal with enforcement via the local authority. So what is changing? What is the Act bringing in that's different under the rent repayment order? It's expanding this to include superior landlords and potentially where the landlords are company directors. Again, you see more and more now what is called rent to rent, where effectively the owner of the property then sublets to, as it were, a landlord themselves, a sub-landlord who then rents the property again. This will effectively bring in the superior landlord into the equation, and it also brings in where the letting company is a limited company, brings in the company director. So again, extended powers. Repeat offenders will be liable for the maximum amount of a repayment order, which, as you can see on the slide, is being extended from 12 months rent to 24 months rent. So there's discretion, as it were, as to where you are on the scale on that. But the fact that it's doubled shows that these renters' rights are certainly being increased. And then finally, tenants or local authorities will have up to 24 months to apply for the rent repayment order. So again, another sanction.
Thank you, Graham. So as we have discussed, there really are a lot of changes being made by this Act, which will have a practical difference on how existing tenancies are operated as well as new ones. Now, the government has produced an information sheet summarising the changes made by the Act. Now, it is the landlord's responsibility to ensure that this information sheet is served on all existing tenants, where the tenancy is an assured or an assured short-hold tenancy, was created before the 1st of May 2026, and has wholly or partly written record of terms. So if that is the case, then the information sheet needs to be served by the 31st of May 2026. Now, if your tenancy is based entirely on a verbal agreement and that was made before the 1st of May 2026, then information sheets should not be served. Instead, the written statement setting out the key terms, which I discussed earlier in this talk, should be served. Now, if you are a landlord and have a letting agent who manages the property on your behalf, then the agent must provide the information sheet to the tenant, even if you have already also done so. Now, this also needs to be served on each person named in the tenancy agreement, and can either be done in hard copy or electronically, such as by email or even by text message. But if it is served electronically, then the PDF needs to be attached. It is not going to be enough just to send a link to the information sheet. So once again, a failure to provide the information sheet could leave defaulting landlords in being fined up to £7,000. So moving on to the timelines. When exactly is all of this happening? Well, the reforms are due to be implemented in 3 phases. The first phase is just around the corner and on the 1st of May 2026. Now, as you will see from the slide, a lot of measures kick in on the 1st of May, which means that we only have a few weeks left to get our head around the changes and be ready to implement them. Further changes, like the database and the Ombudsman, will come in later once the government consultations have finished and there is an infrastructure and personnel in place to get them up and running. But having said that, it is thought it could be introduced as early as late 2026. So it is something that we could see this year. Arab's Law and the Decent Home Standard is not an immediate implementation and the dates are undecided, but it is thought it could be introduced in or around 2035. Now, for the time being, there are 3 critical dates that landlords need to be aware of as the reforms transition in. Firstly, the last date to validly serve a Section 21 notice is the 30th of April 2026. Now, I must stress that this is the last date the notice can be served, not sent. With the rules around deemed service in mind, then really we would not recommend or accept any instructions to serve a Section 21 notice after the 24th of April, as it would be too high of a risk that valid service cannot take place in time of the deadline. So please, if you are considering serving a Section 21, get it in as soon as possible. Now, the next date is the 31st of May. This is the deadline for a few things. So as I've already mentioned, by this point, landlords must have served the information sheet on all existing tenancies of if it's written. Further, landlords also need to have served an existing tenant who does not already have a written tenancy agreement with a written statement of terms. Landlords of student HMOs also need to have this deadline in mind. They must notify their tenants if they intend to rely on ground 4A in the future. So if you are a landlord of student HMOs, you should act now, or you could risk the ability to use that ground later on. Now, the final key date, for now anyway, is the 31st of July 2026. Well, this is the final deadline to apply to court for possession using the Section 21 procedure. Now, for the avoidance of any doubt, that is not the deadline to serve the Section 21 notice, but the deadline to apply to court off the back of a validly served and expired Section 21 notice. Now, after this point, Section 21 will no longer be available at all, and landlords will have to solely rely on the updated Section 8 grounds to obtain possession.
Thank you, Ellie. So that really concludes the overview of the Renters' Rights Act that we're presenting today. It's just really to sum up and look at sort of the consequences and how the Act will impact. I think really it's a wait and see at the moment. We're still waiting for more to be rolled out, and again, it may come in smoothly. But I think it's quite obvious to us, and I think to everybody listening to this, that the changes the Act brings in will have a significant impact on landlords. They're effectively more regulated and more scrutinised than I think they have probably ever been under the Act. And there are certainly more sanctions for any breaches and more opportunities for them to be the subject of sanctions. We have potential Section 8 issues if you don't get that right. We have rent increase issues. We've got the database and the Ombudsman registration issues. We've got the Ombudsman's findings of any complaints. And then we've got local authorities also being able to have a look around, and impose fines and enforce. So all of this really, it is a burden, and I think it's important that landlords take the time to understand and implement the changes. But I think overall, the concern, certainly if we look at the press, and certainly I suppose in terms of this office and the discussions that we've had at Pretty's, the concern is that it's likely to potentially lead to a number of landlords deciding that they've had enough and getting out. It's an interesting one. Certain areas will obviously be hotter spots than others. Student letting might be a hot spot. If you have a let in the middle of a town or city where there's a higher turnover, or people come in, take for example Ipswich, interns come in and say, well, I can have Astral Park, and then move on in a year, 6 months. Those types of changeover, turnover will potentially have an impact. But so will longer term scenarios of rentals, etc. It's really hard to judge. If you've got a long-term tenant who's good as gold and they don't cause any problems and accept rent changes and you're a reasonable landlord, things could carry on as normal as long as you, as it were, abide by the rules and keep your nose clean. But back to the reality, the concern is a lot of people are going to be selling up their stock and getting out of the housing market as landlords. And as a result of that, I think that's also going to have interesting impacts on people who do rent, on younger people who can't get on the property ladder, and on the economy in general in terms of the number of landlords and the encouragement to be a landlord over the past few years. I appreciate it's been gradually perhaps tailing off with tax and selling up letting companies, but overall, the advice has been consistent. Property prices go up. If you're retiring, it's a good way to get a sort of second income. So it is, I think, it's an interesting time and we're watching it closely. So that's really where we are. So in conclusion, thank you again for coming. Please email us your questions and we will try and either answer them or add them to our upcoming fact sheet. Fact sheet is to follow next week. We are likely, I think, to have a follow-up session on this when we don't know, in legal terms, probably a year is, sensible so that we can get some cases under our belt. But if you would like a follow-up session, please let us know. If there's anything in particular you want us to cover, please let us know. And that doesn't even necessarily have to apply to now. If you're a letting agent or a landlord and you see something you'd like us to comment on that you're hearing a lot about, we're happy to, we'd be interested to know. Please don't forget to provide us with feedback, that's important. And then just to come on, there's a couple of slides of useful addresses which are here. Again, remember these will be emailed out to you, so no need to take a screenshot. We'll try to cover the hotspots there. And then finally, just our contact details. As I say, if there's anything you need, please don't hesitate to get in touch with us. And thank you very much. So it's goodbye from me, it's goodbye from Ellie, and we'll see you at the next one. Thanks very much. Enjoy your Easter.
Thank you very much. Bye.